Hello and welcome to the YouTube channel D Creations Resources. We are looking at different aspects from research methodology, and currently we have been talking about patents. So in the previous patents you've already learned what a patent is. So now you know that it's a legal document that gives the inventor exclusive rights to make, use and sell their invention for a certain number of years, and in exchange for this exclusive right the inventor publicly discloses details about the invention. And there has to be some kind of a process in order to get a patent. It's a pretty tedious process, but one needs to go systematically. Now the first step is similar to the first step that you use in a research proposal, and it's logical because it's about patent search. So you have certain patent in your mind, but you need to first check whether someone has already got a patent on it. Remember when we were talking about research proposal, that time also literature survey was very important. You needed to know that whatever was your aim, you had to check whether someone had already worked related to your aim, and what work had they done, and whether there are any loopholes that you can address, and so on and so forth. Similarly here, and it is very important here because you can't get a patent on something which is already patented, right? You can't get an identical patent. So you need to check. So there are databases. For example, online you can find Google patents, or there is a database titled USPTO, United States Patent and Trademark Office, etc. Now, of course, once you are sure that the patent you wish to apply for does not already exist and it's unique and novel, then of course you need to file a patent, you need to apply, and you need to give detailed description of the invention. In the last episode we have seen that in exchange for this exclusive right to make, use and sell the invention for a certain number of years, the inventor has to publicly disclose details about the invention. So you need to describe it thoroughly, as in how does it work, how is it made, or any other specifications, characteristics with respect to it. And then you need to make a claim, and your claim has to clearly outline the specific features of your invention that you wish to protect. So if necessary, you can incorporate detailed drawings or diagrams. Of course, a patent doesn't come for free. You need to pay a substantial amount of patent fees to whatever patent office where you are applying for the patent. Now, once you have submitted your application, the patent office will review your application, and sometimes they may even ask you for some additional information or amendments which you need to provide. If your application meets all the legal requirements, the patent office will grant you your patent. That means now you have exclusive right to make, use and sell your invention. Of course, as I had mentioned earlier, it is limited to the geographical territory where you have applied it for. Now, there are some people who also license their patent to others. So, for example, if someone has worked out certain process to manufacture a product and now has a patent over it, but is unable to manufacture the product himself or herself. So, in that case, the person may license the patent to someone who is able to do that. Also, you need to remember that the patent is for a certain number of years. Typically, it is 20 years, after which you will not have that exclusive right. So, what are benefits of patents? One clear benefit is that you get those exclusive rights for making, using, or selling it, and it can also be used for monetization. Like as I mentioned just now, you can license the patent to somebody else, or you can sell the patent rights to someone else when you know that you may not be able to make use of it to prepare a product or so on. But having a patent is definitely a recognition. You get this official recognition for your contribution to the field. Now, if you wish to list the limitations of a patent, first thing, of course, is cost. The patent process can be very expensive, and many a times people hire a patent attorney or agent to help navigate the process and to ensure that your application is robust. So that professional help will also cost you something. So sometimes the patent is filed through the institution to which a person belongs. Of course, that means that the institution gets exclusive rights. And so whoever is paying is getting those rights. So even when the patent is to be sold, for example, there might be a ratio, like how much would the institution get, what percentage, and how much would the individual inventor get. Well, this differs from case to case, but cost definitely is one limitation. And another limitation is the limited duration. You can't have a patent forever, right? It expires after a certain number of years, like 20 years, many a times. And after it expires, the invention enters the public domain. Now, another limitation you would say is the public disclosure that you need to make. So, we saw that when you're filing a patent, you need to give all the details of the invention. So, when the patent is granted, these details become public. They are no more a secret, and others can build up on these details. But that's a limitation you have to face if you want to get a patent. So, although this is a disadvantage from the point of view of the individual, from the point of view of the community in general, this could look like an advantage, because here patent is fostering innovation and it is encouraging inventors to share their creations with the world, and that can lead to some further research. But for an individual person, cost, public disclosure, and limited duration could be limitations, while exclusive rights, monetization, and the recognition could be the benefits. Now, there are types of patents. There are utility patents, which are for new and useful inventions or discoveries. Then there are design patents for new, original, and ornamental designs, while there are plant patents, which are for new varieties of asexually reproduced plants. So, all in all, getting a patent is quite a tedious process. It is complex and time consuming, but it provides you significant protection and benefits for your invention. And it is definitely an advantage for the community as a whole. So, as a researcher, it is important to be aware of what patents are and how to file a patent, what are the benefits as well as limitations of a patent. And if you feel your research is patentable, then you can approach a country's patent office. For example, it is USPTO for United States, it is EPO for Europe, or IPO for India, and so on. Thank you.